Hello. We're going to try and do part 3 of the Unit 6 study guide. Knock out a big part of the judicial branch for you. Um, so 3A, describe the difference between strict and loose construction. Alright, let's tackle the word construction first. There is a verb that you probably don't hear very often, construe, to construe. If you construe something, it means you interpret it or you understand it a certain way. So if you take the word construe, which means to interpret or understand, and make it into a noun, you get construction. So your construction of something is your understanding or your interpretation of it. Usually it's instructions you've been given, maybe verbally by somebody else, or maybe a text, a written text, like a law or a constitution. Your construction is your way of interpreting or understanding that document. Strict and loose are two different ways to approach reading and understanding and interpreting what something says. Loose construction means a broad interpretation that allows the person doing the interpreting, that means you, the person reading something, it allows you to insert your own meaning into the text and sort of read between the lines. You can say, oh, well, it's not clear, so I'm going to decide what it means using my own brain. It's most likely to happen when something in the text is unclear or vague, and you know, some people will say, well, I have to make sense of it somehow, so I'm going to add what I think I know, and I'll interpret it this way. Loose construction means you take what you're reading and you add meaning from your own brain because what's on the piece of paper is maybe not completely clear. Strict construction is the opposite. It means you're sticking literally to what the words say and the meaning of those words. You're not allowed, you don't feel yourself as being able to contribute meaning out of your own head. You're willing to just say, well, there are the words, this is what the words mean, and I'm not going to change what it is, read between the lines or anything. It's easier to do this when the meaning of a text is kind of specific and clear, but obviously when we're talking about the Constitution, that's not always possible. I'll give you an example between strict and loose construction. As you know, that there's an important phrase in the Constitution called the necessary and proper clause, also called the elastic clause. Well, okay, take that word necessary. The word necessary or need technically means you can't live without something. I need food, shelter, and water to survive. So if you interpret the word need or necessary strictly, then statements like I need cable TV or I need a cell phone, those statements don't make any sense because you don't literally need them to survive. And that's what the word need or necessary implies. That's what the meaning is. In the necessary and proper clause, what if the Supreme Court interprets it to mean, the word necessary to mean literally vital to the existence of the United States? What's the case that we've studied where the necessary and proper clause was first interpreted? The McCulloch case. What led to the McCulloch case? Congress created a national bank. So I guess reading the Constitution strictly, using strict construction, the Supreme Court should have said that that bank was unconstitutional because it was not vital to the existence of the United States government or the nation as a whole. However, the Supreme Court engaged in the opposite of strict construction, which was a little bit of loose construction, and basically said, well, if Congress says we need it in some sense, I mean, it would be helpful to the country, it would be convenient to the country, like a cell phone or cable TV is, to you as a person, then the Supreme Court allowed Congress to get away with creating the bank and interpreted the word necessary loosely, not strictly. So that's one example of loose construction that was important in the development of our country. I'll give you another example, and And at this point, it'd be really nice if you had read the summary of the case Griswold versus Connecticut. Because that case is the absolute perfect. It's the best example I can give you. It is the absolute perfect example of loose construction, interpreting a constitution loosely or broadly. So I'm going to assume you've read this. Basically, you should already know that there was a Connecticut law that back in the 1960s, look at the dates, this is not too ancient history, I was 4. Back in the 60s, Connecticut, like some other states, had laws banning basically the discussion of contraception. Even married couples were prohibited from going to someone to get advice about contraception. If they didn't want to have children or wanted to engage in what we now call family planning, they could not get advice from a professional about how to not have children. I know it sounds like, the Middle Ages, but it wasn't that long ago, like I said. Anyway, there's a Connecticut state law that said you can't give advice to married couples on how to not to have a baby. Well, somebody did it. It was a Planned Parenthood clinic in Connecticut. They were doing this. They ran afoul of the law. It was a crime. So it turned into a court case. It was appealed all the way up to the Supreme Court, and the Supreme Court surprised an awful lot of people with its decision. I think if you just you don't even have to read the Constitution. Is there anything in there about having babies, or not having babies, or contraception? Of course not. There's nothing like that in the Constitution. So, how is the Supreme Court supposed to decide? Is the state law in Connecticut constitutional because it prohibits something that the people of Connecticut apparently want to prohibit? Is it constitutional because of that reason, or is it unconstitutional because it disagrees with something in the Constitution, when there's nothing in the Constitution about talking about contraception? Well, the Supreme Court did, in its decision, hold the Connecticut state law to be unconstitutional. Well, what did it violate? That was the interesting question. What in the Constitution did the Connecticut state law that said you can't discuss contraception with married couples, what was in the Constitution that disagreed with that? Well, what the Supreme Court did, and this is the reason why I think it's a perfect example of loose construction, what the Supreme Court did was they went through the Bill of Rights, which we will do very shortly in class, and I ask you to read box number 6. They found lots of references to where people have the sort of reasonable expectation to be able to do things without government interference. The First Amendment refers to freedom of speech, freedom of association. The Fourth Amendment protects you from unreasonable search and seizure. The Fifth Amendment protects you from a variety of things from the government. The Sixth Amendment protects you from a variety of things from the government. And what the Supreme Court decided in 1965, which it had never decided before, was that there was a right of privacy somewhere in the Bill of Rights. The word privacy does not appear in the Bill of Rights. None of the amendments specifically address that exact situation. And what the Supreme Court in 1965 did was they found little pieces of privacy, privacy from the government basically, and they created a whole new right that wasn't there before, a right to privacy, a federal right to privacy. And they overturned the Connecticut state law that said you couldn't discuss contraception with married people. It is the perfect example of loose construction, because what the Supreme Court did was they found something that literally isn't there. They kind of took pieces from here and there, words from here and here, and they nailed them together and created something that wasn't there before, which is, that's exactly what loose construction is. Strict construction would have said, there's nothing in here about it. There's nothing that says a state can't do that, so the state law stands. But that's not what the Supreme Court did. So I hope that helps give you some idea of what the difference between loose and strict construction are. Loose construction, broad interpretation of the Constitution. Strict construction, a very strict or literal interpretation of the Constitution. That's 3A. 3B, the difference between judicial activism and judicial restraint. Okay. Both of these terms refer to this: a judge's attitude towards how they should use their power. Pay very close attention to what I'm saying here. Judicial activism and judicial restraint are basically two different kinds of attitudes that a judge might have when addressing these topics. How often should a judge exert their authority over the other two branches? How often should judges exert their authority over states? And should judges always feel bound by precedent, that means previous Supreme Court decisions, or should they feel comfortable overturning old decisions and creating new precedents? Those are three questions that someone who believes in judicial activism will answer differently from someone who believes in judicial restraint. Judicial activism means this: judges are willing to engage in loose construction. They are willing to overturn state governments' laws and even laws passed by Congress and the President. Judicial activists are willing to sometimes ignore previous Supreme Court decisions and maybe overturn them or create a new precedent that was never basically decided upon before some new case. Judicial restraint means the opposite. Judicial restraint implies that judges should interpret the Constitution strictly. That means engaging in strict construction. Judicial restraint means judges should defer to state governments. That means allow state governments most of the time to have laws the way they want them, and to allow Congress and the President to basically most of the time do what they see fit, and not overrule them and not declare their laws or their actions unconstitutional. And the final thing with regard to previous precedent, judicial restraint implies that usually judges are going to feel like they don't have the right to overturn previous Supreme Court decisions, that they have to follow precedent and decide new cases in the same way that old cases were decided. So judicial activism means a judge is willing to engage in loose construction, to overrule state laws, to overrule maybe actions of the other two branches at the federal level, and to sometimes overturn precedent and create new precedent. Judicial restraint implies the opposite, that judges should interpret the Constitution strictly. They should defer, meaning allow state governments to have the laws they want most of the time, and let Congress and the President get away with their actions most of the time, and that the judges should respect and not overturn old decisions and precedents. The Griswold case is a great example not only of loose construction but of judicial activism, because the Supreme Court overturned a state law, and lots of states had similar laws. So it was activist in the sense that it overturned lots of state laws all at once, in addition to its loose construction of the Constitution. The Brown decision, which I hope you've read. Is it? Nope, that's not it. This is it. Here's the Plessy decision. Here's the Brown decision. Make sure you read them. The Brown decision is a perfect example of an activist decision, because it involved a brand new interpretation of the 14th Amendment. The old interpretation of the 14th Amendment was set up in Plessy in 1896. That Supreme Court had said, well, segregated railroads and segregated everything else are fine. Later in the Brown decision in 1954, they said segregated schools are not permitted by the 14th Amendment. So the Brown case overturned a previous precedent, gave us a new interpretation of the 14th Amendment. It overturned all state and local school segregation laws. It's one of the most activist cases ever that come out of the Supreme Court. Make sure you understand the difference between judicial restraint and judicial activism. I referred to it in a previous video. This is one of the considerations presidents have to consider when they're appointing somebody to the Supreme Court or to another federal judgeship. Is the judge that I'm nominating an activist or someone who practices judicial restraint? If I had to sort of generalize, generally speaking, Democrats and liberals seem to prefer judges who engage in loose construction and judicial activism. Republicans and conservatives tend to be opposed to those kinds of judicial philosophies and tend to prefer justices that are that believe in strict construction and judicial restraint. In fact, if you've been watching some of the Republican debates, judicial activism comes up a lot as something bad. Alright, real quick. Original intent, 3C. Original intent or originalism. I tend to try to keep my opinions to myself, however here I have to say this is complete and utter hogwash. Obviously I'm not a lawyer, I'm not trained, but in my own limited brain capacity, the idea of original intent is really dumb. What it means is that in theory, the Constitution should be interpreted using the concepts and meanings as they existed at the time the Constitution was written. In other words, when we're just trying to decide some modern case, some issue that has come up in our society, and we look to the Constitution and what are the words in the Constitution, the doctrine of original intent or originalism says that we have to stick to the meaning of the word in the Constitution as it meant what it meant 230 years ago. So, okay. Lots of problems with that. First of all, a lot of the words in the Constitution are vague. They were intentionally compromised words just to make a lot of different people happy. The Constitution was not written by one person. It was written by at least 55 people. And then, so you're trying to read the mind of 55 people from a distance of 200 years to try and figure out what this word meant to help decide what some modern situation. And to me, it's just wacky. I mean, the term general welfare meant something a lot different 200 years ago than it does today. Necessary and proper meant something different 200 years ago than it does today. Due process, we'll get to that later, but due process, very different sense of what that means 200 years ago versus today. So society changes, the world changes, our attitudes change, and original intent basically means the Constitution can't change. I think that's a bunch of baloney. Anyway, last one. I'll make this one about 20 minutes, so sorry about that. The principle of stare decisis. Stare decisis is Latin for let the decision stand. And what that just simply refers to is the fact that if a certain kind of case, somebody sued somebody over some issue, was decided 100 years ago, and then something similar comes up today, the concept of stare decisis means that the modern case should be decided the same way as the old case was decided. I think it's kind of common sense, because everyone wants the law to be predictable, everyone wants the law to be fair, no one wants the law to say, well, in that situation, that person wins, but in the same situation now, the other person wins. That's not fair, that's seen as arbitrary. If you want rule of law, if you want a consistent, predictable, trustable legal system, you have to believe at least a little bit in the principle of stare decisis. Let the decision stand, and our legal system is basically founded on it. Once in a while, judges will depart from stare decisis, but they usually have a really good reason for doing so. For example, in the Brown decision, they didn't let the Plessy decision stand. They found a good reason to overturn segregation laws, at least in schools, and that was probably a good thing. So, stare decisis isn't followed 100% of the time, but it's followed most of the time, and it's a good thing. Okay, so that's all of part 3. I'll see you in the next video when we do part 4.